David Sobel, and I'm a Michigan real estate and finance attorney. Today, I'm going to answer a question from a viewer related to her inheriting a piece of real estate in Shelby Township. So it comes from Marlene from Shelby Township, who writes, let me see here, I'm going to put on my glasses. I want to sell a home that I inherited from my mother. I owned the home together with my mother before she passed in 2012. I know this because we created a deed together about a year before she passed. Okay. My sister says that my mother left the home to both of us in her will, and therefore I cannot sell the home without her permission. I looked at the will, and it confirmed that it does say that. Marlene asked, what do I do now? Do I have to go to probate before I sell this home? She states, I thought I owned this home outright. Well, it's a great question. And, before I answer it, I just want to say that I would need to have any attorney would need to have copies of both the will as well as a copy of the deed. And it would really be helpful to know when your mother created her will and also the date of the deed. See, it's very likely that at the time she had the will drafted, she had intended to leave the home to perhaps your sister. However, at a later date, she had a deed drafted naming you as a co-owner. And then the deed may actually prevail, because if she did this deed after the will, it's very likely that she intended for you to have it. Now, I say may because deeds have to state what we call the magic conveyance language. It's the legal language that everybody talks about. And when a property title is to be transferred between parties, you have to have that magic language. So if the deed names the two of you jointly with rights of survivorship, you become the sole owner of that property at the time of your mother's death. However, the deed named you, if the deed named you and your mother as tenants in common, well, then you and she owned the property equally. But the problem is, upon her death, her interest then goes to your sister, as she stated in the will. So it could be possible that your mother did want your sister to have her interest in the property upon her death. That means you and your sister actually own the property together. That is only if the deed says that. So in the event that this deed named you and your mother as tenants in common, then the property must be transferred by the personal representative of your mother's estate. So in other words, you're going to need to make sure that you and your sister go and have this property probated because it's tenants in common. And after you have the property probated, then in order for you, Marlene, to convey the property, in order for it to be marketable, you're going to need to have her permission. So ultimately, you should really have a real estate attorney review the deed in question as well as the will. But this was a really great question, Marlene. I'm going to tell you why. It really demonstrates the powerful impact that legal conveyance language has. And it's so important. And many mistakes occur when people try to create deeds without the benefit of legal counsel. And it also shows how different areas of the law are really interrelated, and that engaging in one area of the law without professional assistance, really may have unintended consequences impacting your legal rights when it comes to another area of the law. So great question, and thank you very much. And I encourage people to write in. I'm David Sobel. I'm a real estate and finance attorney. Again, if you have any legal questions or any concerns, please feel free to contact me at 888-789-1715 or contact us at provenresource.com. And thanks again for watching. www.provenresource.com is the best way to reach us. Take care.